All right, so welcome to Atma webinars. I'm Aishwarya. I'm a lead consultant at Atma. We have been working in the space of organizational development and capacity building of NGOs since 2007. The Atma webinar series started in 2017 as a platform where speakers share practical experiences and knowledge that can benefit NGOs. And we cover various topics under HR, finance, fundraising, communications, and other OD areas. You can find all our past webinars on our YouTube channel, and we'll share a link to that post the webinar in a mail that we send you. We also offer a searchable, verified intermediary database, which we have built in collaboration with the Pay What It Takes initiative. We'll put the link to the database in the chat box. The database is intended to help NGOs identify service providers in their area of interest and work with them on building their organizational capacities. Towards the end of the webinar, my colleague Kavita, who has worked on this initiative, will be taking you through a short demo. But let's start with the agenda for the day. We're really grateful to the speakers from Pacta who are going to be taking up a topic which is very critical, but probably not as well understood in the sector. We're going to be talking about compliances in the space of employment. I'm going to begin by introducing our speakers for the day. We have Nivedita. Nivedita is a law and public policy consultant with 15 years of experience in the corporate and social sectors, focusing on inclusion, data, technology, and philanthropy. She has addressed data privacy issues in the public health, gender, and employment spaces, and is a legal consultant for the Azim Premji Foundation. Through Pacta, she has produced evidence-based policy briefs on disability and technology for governments, multilaterals. She's a member of the Institute of Company Secretaries of India and holds an LLB from ILS Law College, Pune, and a master's in public policy from Princeton University. Welcome, Nivedita. Next, I'm going to introduce Dishari. Dishari is a law and public policy consultant with 8 years of experience in litigation and the social sector, specializing in governance, inclusion, data, and technology. She has led Pacta's legal vertical since May 2023. Dishari holds a BSc LLB from KIIT School of Law and a MPG from Azim Premji University. Her work focuses on legal and policy solutions for civil society organizations, emphasizing philanthropic and technological initiatives. Before we begin, just a request to all members of the audience to put their questions in the chat box whenever they need to, and we'll take them up whenever appropriate. There's also a dedicated Q&A space towards the end of the webinar. This will just help us maintain the flow of the webinar. And आज का जो सेशन है वो ज्यादातर इंग्लिश में होने वाला है, लेकिन अगर आपको हिंदी में कोई ट्रांसलेशन चाहिएगा तो प्लीज चैट बॉक्स में बताइएगा और आत्मा की जो टीम है आपकी मदद करेगी. Yeah, with that, would love to hand it over to Dishari and Nivedita to take things forward. Yeah.
Hi, I'm Dishari. I would be leading the session, and Nivedita is also there to support. And as and when required, please, as Aishwarya said, please ask the questions. We will try to address them. And we have also taken questions during the registration. So whenever we deem fit that the questions can be answered, we will try to answer those questions. With that, I would like to share my screen and start the process. So yeah. Yeah. So in this, as already told by Aishwarya, we would be understanding the employment regulation in the NGO space. And before doing that, I would like to briefly introduce Pacta and what we do. So Pacta was founded by Nivedita in 2017 when she understood the need for having a law firm specifically for the needs of the social sector, because we know how other law firms function and they do not have the adequate knowledge to and expertise to support the social sector also, and to make it cost effective. So with that intention, she established Pacta, which which provides legal services to civil society organizations with compliance, contract drafting, internal policies, risk mitigation, governance structures, legal research, etc., etc., where you can visit our website and see our work. And at the end of the session, at the end of the slide deck, you will find the link to our website and our work. And we also do some research initiatives, which necessarily tries to bridge the gap between the implementation and the practice. So in the social impact implementation and the theory. So we want to bridge through our research, we want to bridge that gap. So having said that, I would like to get into the agenda of the session, and let's begin. The agenda is very simple. First, we will try to understand that what are the nature of employment and engagement in social sector, because we come across terms like fellows, volunteers, full-time employee, part-time employee. There are a lot of terms going around, and there are types of engagement happening. We would like to break it down first and understand which means what, and then we will come in the second part of the presentation. We will try to look at the laws which are applicable to the NGOs, essentially what the laws which you encounter in a day-to-day basis. It's not that it is exhaustive, but we will try to cover the basics of it so that we can give you some practical knowledge. So before going to, if you can put in the chat box, what are the type of employments you have in your organization? Just in a 2 minutes, if you can fill in the chat box in an organization, what are the type of engagements you have, employment engagements? Yeah, we are getting a couple of responses. We can see part-time, full-time, contractor, consultants, volunteers, interns, fellows. So having all these understanding, let's get into understand what the principles of employment are under the law first. Then we will get into the specifics of it, how these nomenclatures functions, and what under what we can put what. Okay. So just this. There's a glitch in between. I think the screen is not moving. For you, is it moving?
No, Dishari, it's on the types of employments title slide.
Yeah. Yeah. Okay. Sorry for the glitch in between, and apologies for that. So we are getting into we will try to understand the principles of employment and engagement. So under law, there are two basic principles under which these engagements or employments are governed. One is called a contract of service, where we essentially see the nature of direct control. If you have a direct control over your employee, when I say that there is an established employee-employer relationship. That person is not employed for a particular specific task. He is employed for a role, and he will have an activity day-to-day activity within the organization, and will be directly working under the instruction of the employer. So that's a direct supervision we are talking about. It's not a one-time work that that person can do and move out of the organization without having a direct control uh, of the employer. So when we see, and this relationship is the traditional employee-employer relationship or a full-time employment relationship where we recruit a person for a role, and that person continues in the organization with the normal progression, like with promotions, with review, with appraisals, with everything, and that person is given leaves, then other statutory benefit which they accrue, like provident fund, retirement contributions, gratuity if they have completed 5 years in the organization, then they are leaving. So all these, and that's why, and there is a progression, and in that progression, the employer has a control over that person. Now, the common confusion we have seen in this aspect is that people like the social sector tend to think that a fixed term employment, like a fellow or like a contractual staff, are not entitled or does not fall in this purview. They think that they can be removed from all these things, although they are performing the same job. And in this sector, the understanding is, if this is a project based work, then this person is coming from for a fixed term, and then after the project ends, they go out. And therefore this the normal supervision does not happen, although we have to understand that this happens. Even if it's for a fixed term, you have a control over their working style, their working delivery, their whatever they have to deliver. You have a direct control over that, and therefore they should be entitled to paid leave, provident fund, ESI, etc., whatever accrues. Are not they cannot be divested of that. You cannot. So that's on the contract of service. But on the contrary, there is another concept called contract for service. This model is different. In this case, this person is given a specific task for a specific time period and for a specific expertise. And they are usually our consultant, our professionals who we bring in for a specific to execute something specific. And they are not performing a day-to-day task. And also they are removed from all these appraisals, employment benefit, they don't, and paid leaves, etc. They are not entitled to this, and they do not have the same legal protection as an employee. So there is a distinction between these two categories, and often it has been seen that these two categories are like mixed up, and clear demarcations are not made between these categories. To understand the demarcation, what we have to very specifically understand is this: whether what type of job this person is doing, in what capacity this person is being brought in, and how and what control the organization wants to have over their work. It doesn't mean that you are not reviewing a work of a consultant given by delivered by a consultant, but what can you make a significant contribution? Do you have the same expertise as a consultant bringing in? So that we have to think in that line to clearly segregate between these categories. And when we segregate these between these categories, we understand who gets what kind of benefits. So having said that, then we will move on to the tried to bucket based on our understanding who falls under what category and how they can, what benefits and what relationship they share. And this slide is self-explanatory, so you can take a look, pause for a minute, and you can ask your questions in this if you have any confusion.
Shari, there's already one question in the chat box. So the question is an employer required to cover fixed term contract staff under the organization's insurance policies? Would that expose the employer to any form of risk?
That is not explicitly said anywhere under any law, right? Insurance is a benevolent activity an employer does towards their employees. If you want to extend it to your FTEs, that is a call, internal call you have to take. It is at your discretion. There is no statutory mandate for you to do that. And therefore, the risk exposure is a lot lesser. I can say that.
All right, there's one more question which has come in, which we can take as well. This is from Rajesh, where he says, in our NGO, there are about 5 permanent employees, while others are on contractual basis for a specific project. So they are there till the project duration is there. Will they be covered under ESIC if their remuneration is below the maximum limit set under the ESIC Act? Rajesh, we will be talking about ESIC and other regulations a little
and
later.
I will come to this question, and I will answer this question when we come to that point. There was one question I found during the pre-registration questions. There's one, how we manage staff with mixed employment type. So the particular look, organization, I don't know who posed this question, but an organization, if they have a mixed employment type, the advisable is that you segregate them into categories, proper categories, have specific policies for those categories. Like if you have permanent staff, full-time employees, have policies for them, HR policies which are applicable to them, and how they will be governed, what are their code of conduct, everything, what are their benefits. And you have for fixed term employee, you have another set of policies, or you have a set of policies which applies to full-time and fixed term, and then you have consultants. So there are 2 ways to do it. One way is having specific policies for them, and another, their agreements, their engagement letters should be very specific on their role, what are their conditions, what are the term of their employment, what are their benefits, everything should be very specifically mentioned in their engagement letter, and that should be maintained properly. So that is how you can manage mixed type of employment, and this is a very common phenomena across all organizations. Is there any other question?
There are a couple of other questions, but we can take them up later in the session. You can move on. Yeah.
Okay. There's some problem in like changing the slides. It's getting stuck. So we will be covering the legislation which are applicable to the space. First, I want to say one thing, make it very clear. All labor laws legislation apply to the NGOs unless specifically exempted. Why I say that there is an understanding that a lot of legislation does not apply to them. So therefore, the bottom line is everything applies to you unless you are exempted. Like an exemption, I can upfront say that Payment of Bonus Act exempt the NGO sector, the social sector, from paying bonuses to that limit, that specified limit of 21,000. Any person receiving salary of 21,000 is entitled to bonus. So the social sector is exempted from that. But there are also the other act we are talking about, the shops and establishment legislation, which is a state specific legislation, and each state has their own definition. We are going by the definition, a generic definition given by a Karnataka High Court, which obviously applies to in Karnataka. For your state, we would be requesting you to look up your Shops and Establishment Act and see whether it applies to you. And when it applies to you, it has specific requirements of registration, your leaves, working hours, etc., etc. Like the major confusion here happens is a lot of legislation, like legislation in terms of shops and establishment in a lot of states, they say commercial establishment. So when they say commercial establishment, the general understanding is that the social sector is exempted. But it is not. You have to go into the definition of it to understand whether you fall into that definition or not. And there's another thing which happened. The Maharashtra Shops and Establishment Act removed that confusion and removed the commercial word from the definition of establishment and made it establishment. So they said that any establishment which has been defined in this section needs to be falls under this legislation and needs to follow the requirements under this legislation. And they have given 3 specific exemptions. One of the exemption being the educational institute established under the state acts, okay, or has registration from affiliation from any state or central board, means schools are exempted from this. Otherwise, there is no specific exemption for the social sector as a whole. So when we talk about it, we have to understand where it applies, how it applies, and what are the requirements for it. So because it's a state specific act, we could not cover it in its entirety, but I can tell you a few things which you need to watch out for. One is, does your organization need a registration under shops and establishment or not? What are the requirements of that registrations? Then if you are registered as a shops and establishment organization under that legislation, then you would be needing to follow their prescribed working hours, holidays, and wages. Then you have to also see that what are the requirements of women working at night, then how the name board outside your office should be having what is the proportion of the name. Like some states need their name to be in vernacular language plus English, and you have to display your registration number, right? So all the registration number or the certificate, and all these things you have to see in your these things actually you have to see in your state specific laws, legislation. And it is also obviously it does not have imprisonment if you don't. It has a fine, so the risk is slightly lower, but still you have to see for yourself what is the applicability for your organization. Then we will come to, again, another important thing is P-tax, professional tax. Again, for professional tax is a legislation which varies, rules actually varies state to state. You have to get to your own state's portal to see what are the cadence of submission, who are the employees for whom you should be deducting professional tax, what is the quantum of it. Usually it is around 200 rupees. But still you have to see the quantum of it, who are exempted, for whom you cannot do it. There are also exemptions. There are also filing requirements. Some state ask for a 6 months filing, some ask for 3 months for filing, or a yearly filing, you have to check for yourself what is the cadence of filing also. And I think your chartered accountant would be the best person to help you to understand this if you have one. And also there is a penalty for it. It is varies state to state. It might be 2%, 3%, 1%. And for false information, there is a penalty. So 3 times of the tax amount. So you have to be very careful about how you are filling out the details of your employees and how you are paying. So these are the two acts which we are talking about state specific. Now we will be moving on to acts which are central acts and which are uniform across, but some of the acts might have state rules. So you have to check, watch out for them also. So now we will be coming to a very act which is the Employees Provident Fund, EPFO or EPF, PF, whatever we call it. So we have to understand first, we have to say that if you have 20 employees in your organization, you have to register with the EPFO. That's a mandate by the act. You have to do it. Now there are questions that, okay, I have 3 permanent employees, I have 17 contractual employees. Means you have 17 employees, means you have 20 employees, you have to register for it. Even if it's a contractual employee, they are entitled to PF. That's why in the beginning I told you that contract for service, what is the type of their engagement? Are they coming on a particular time period also in a project? That also matters. And what is the task they are performing, how they are performing. And if you're saying that these are project-based staff, in that they are also entitled to PF and they are entitled to PF mandatorily if their basic salary is up to 15,000 rupees. Beyond 15,000, there is an option. They can exercise an option of not taking it or taking it. That is not a mandate, but for employees whose salary, basic salary, and basic means basic plus DA, and that has been a Supreme Court judgment. So basic plus DA plus any other employment benefits which is given in cash and is given to all employees of that cadre needs to be considered while calculating 15,000 rupees. That has been a case law by the Supreme Court in 2017, after which this the calculation, what is basic wage, the definition of it slightly changed. So we have to consider while calculating PF, what is the basic wage? Basic wage means the first is your basic wage plus DA plus any benefits which is given across the establishment. Maybe a food allowance or a medical allowance for 200 rupees. So 200 rupees is given to everyone. In that, irrespective of their designation of their level, 200 rupees is allocated to everyone. So that has to be also considered. So therefore, and the contribution is 12%, employees contribution, 12% employers contribution. And you have to understand that the employer's contribution cannot be deducted from the employee's contribution. It should be employer's contribution solely. And remember, if you do that, that's a punishable offense under the act. And there is an imprisonment linked to that. So while you're, and there's another question which comes here is where people ask, okay, we are paying someone 30,000, but we are contributing only 1,800. The PF based on their basic. Is it okay? Yeah, that is okay, because you can, the minimum, the maximum, the minimum is, even if their salary is higher, you have to pay 1,800 as from 1,800 from their contribution, employees contribution, 1,800 from your contribution. That is the basic you have to give. Then the basic another thing is that when you deduct the salary, deduct from their salary the contribution, you have to submit it within 15th of every month. Okay, and with the EPFO. And there are two forms which are filed. This is self-explanatory. I will not go into details. There is a 3A which is for the regular, and 6A is a consolidated form you have to file every year. So that's also, and there are delays. Other than your deduct, there is only one punishable offense, which is punishable with imprisonment, is if you deduct the employer's contribution from employee's salary, that is punishable. Other than that, for non-compliance, it's only fine, but the fine can be 100% of the fine can be 100% of the amount, the interest plus the penalty. So when you do not file, suppose you are not filing for 6 months, okay, then you have to pay 6 months your interest with the amount, plus you have to pay a fine. It can go up to 100% beyond 6 months, like depending on the delay you cause. So it is the initial, they have 5, 10, 15, and beyond which it gets only compounded. So then we will move on to the ESI. Again, ESI is any organization which has more than 10 employees, you have to have ESI. And anyone who is earning up to 21,000, you have to contribute. You have to give the ESI benefits to them. So the question I will take here is, someone asked just earlier that if you have 3 permanent staff and all project staff, and their salaries are below 21,000, they are amenable to ESI, and they should get ESI benefits, and you have to do it. Even if you have not registered yourself as an ESI organization, please do it and start paying them ESI contribution, which is 3.25% of gross wages, and employees' contribution is 0.75%. Although sometimes, please check it, sometimes for some states it varies. So for your state, just check what is the contribution of employee and employer. Sometimes it varies. So just with that, I would like to tell you that please check it before you deduct the contribution. And yes, it's similar to like PF. I will not repeat it. If it's a full-time and a FT, fixed term employment, you are supposed to give ESI and PF benefit mandatorily if their salary for PF is below 15,000, and for ESI it is below 21,000. And there is a cadence of ESI filing. Even if, and there's one thing I want to mention here, is very important. Even if you do not have any ESI employees and you are ESI registered, please start filing your nil filings. Like you do not have it, but still you have to keep on filing your ESIs, saying that nil employees, nil contribution. That's a mandate from their side. Or if you and if you do not anticipate that you will not have any, you're anticipating that you do not have, you won't recruit anyone below 21,000, and they will not fall in that bracket. So please deregister yourself from that. But if you are still registered and you are not filing it, there can be some penalties on you. Okay, so these are so the acts which I spoke about applies to a person on a monthly basis, right? When you account for their salaries, you have to account for ESI and PF. And so this is, and it has to be accounted for someone who is with you for even 6 months, 1 year, or full-time. You have to account for this. Now we are coming to act which is Payment of Gratuity Act. You have to account for this once an employee, like someone who is staying for at least 5 years, 5 continuous years of service he has provided, and only after 5 years during separation you are paying out the gratuity. So gratuity, so when you have like gratuity more than 10 employees, you have to have a gratuity. The usual practice is you register, you must procure an insurance. Like, it's not an insurance, you have a tie-up with some organizations like LIC, with where you in the name of that like against that each employee you have, you start depositing that gratuity amount as a precaution in their name. Once they separate, the payout happens at that moment, and the payout happens from their, like, from the LIC's that scheme. It's a scheme you purchase for yourself. So this is the and again, for gratuity, there are some rules which has been like Karnataka has a specific rules where you take a gratuity insurance, like you tie up with LIC and have an insurance, and the payout happens through that. And there are other states which might have this kind of a rule. But as a practice, a lot of organization does is ties up with this kind of insurance organization, which has this kind of a scheme facility, and each month they accrue that amount of 4.83% with the specific agent they are tied up with. And at the end of their tenure or the time of separation, retirement, they give out the gratuity. So, but now we will go to just one part of it. What is the calculation of gratuity? It is a very basic calculation. It's 15 into last drawn salary into years of service divided by 30. When we say salary, it means basic and DA. We do not add anything else. Daily allowance. Sometimes people will come up that we don't have a like breakup of basic DA. We have a give a consolidated amount of this much. So that is your amount. Then you are not dividing specifically anywhere. So that is the amount you have to calculate for. And only you have to exclude any benefit like travel allowance or medical allowance or anything you have given. You have to exclude all those things if you are accounting for all those things in the salary breakup. So this is these are the rules for gratuity. We have often seen few things that gratuity is calculated in CTC, and employees coming and asking for that if it is accounted in CTC, why aren't we getting it? The request is try not to include in the CTC, or specifically communicate the gratuity rules to the employees once they come and ask for it. That's it. Before going into the maternity benefit, I have covered a lot. Would you like to have questions asked during this time?
Dashari, a lot of the questions that were coming in the chat box, Nivedita has been responding to, but I'll just take up a couple at this moment. There was a follow-up question to the question asked by Kritika, where she had initially asked about accident insurance and accident insurance for contractors, and Nivedita responded saying it's optional. The follow-up there is what is the liability of the organization in case the contractor meets with an accident, assuming it's in the course of work?
Depends on.
Sorry, let me take that.
Yes.
See, first of all, when we say contractor, if you have if it is contractor, the way the law approaches contractor, and not just relying upon the definition of contractor, just because you have a contract employment with them, because we see a lot of NGOs having regular engagements, styled as a contract engagement. If that is done, then the law will overlook the fact that we have used the nomenclature of contractor and will invariably apply the provisions of the Employees Compensation Act, which entitles employees to receiving compensation for death or disability or any other injury that they have incurred during the course of their employment. However, if it is employer under the theoretical and clear meaning of the word contract, which means that somebody is an external third party vendor, or who is an expert, who is a contractor and has given certain services, and if some injury happens, then the company will not be liable. In fact, we highly recommend that while drafting that contract with the contractor, it is clearly written that there is no employer-employee relationship between the parties, and that there are no liabilities in this regard. So I hope I've sort of responded to your question, but the trick is actually following a contract employment in reality. But the thing we see with not-for-profits is that even regular employments are stylized, or they use the nomenclature of contract employment. If you do that, then the law will pierce through and will apply the law irrespective of what we have called it.
I think there was another question on what takes precedence. Is it the policies of the organization or the law? I think I know the answer to that, but Nivedita, Dishari, over to you.
Yeah, no, if there is a conflict between the policy and the law, then whichever is, obviously the law will take precedence. If both, let's say, in one view have said that you will give a particular compensation in case, there is any layoff, right? Then in that case, and that is more generous than what the law says, then whatever your policy says will take precedence. I hope that is clear. So usually the law, but whatever is more favorable to the employee, that one will take precedence.
I think we're good to move forward. There was one question on what all other statutory benefits that employees are entitled to. I know that you're covering that under all of these laws, but maybe a quick sum up after we finish all the acts might just help put that in perspective.
Yes, sure. So the next act which we will be coming to is the Maternity Benefit Act, and also a national guideline for setting up creches. When I say national guideline, obviously it has state rules, and the Maternity Benefit Act also has its own specific state rules. So every organization in that specific state has to look at their state rules. Before going into the state and everything, what is the overarching applicability? It applies to all organizations, irrespective of the number of employees it has. Okay, it applies to everyone, and it applies to female workers, all type of female workers, part-time, full-time, contractual, fixed term. Now, when we say worker, again, the distinction between employee and consultant comes in. So you get your answer there that employees specifically are entitled to this maternity benefit, because as a concept, consultants come and go for a specific task. So therefore, when we are talking about Maternity Benefit Act, anyone who has worked completed 80 days of service in the preceding 12 months before the due date, before her due date, is entitled to maternity benefit. And the leave is leave is 26 weeks. It is divided into two parts. One is 8 weeks. It starts from 8 weeks before the delivery date, and the rest is taken after the delivery date. But there is one point particularly I would like to emphasize, that under section 10 of the Act, if there is a medical reason and there is a doctor's prescription that person needs rest and for other purposes needs leave then extra 4 weeks of leave can be given to that employee. So that's another, it's not mentioned here, but I would like to bring it here so that it is clearer that if someone has under medical condition needs to take the maternity benefit before the 8 weeks, that person can be allowed and should be allowed under the act. Now that's and during that time, the female employee should be given full wages. The wages she has been drawing in that last 12 months. So that's on maternity benefit, and it extends to 2 child. After 2 children, it can be reduced to 12 weeks. Now there is another, in the new act, there's an option of work from home wherever possible after 26 weeks. If the employers feel that the employee can work from home and deliver her work, that should be allowed by the employee. But that is a discretion. It's not a shall clause, it is a may clause for that purpose. A discretion has been given to the employer to accommodate the request of the female employee even after 26 weeks to work from home during that period. And also same applies when we are talking about delivery due date. We have not mentioned, but there's another piece of information we should share is for miscarriage. Also, the employee is entitled to 12 weeks of leave. And for adoption, if the child is below the age of, I think, 3 years, that the female employee is entitled to a leave of 12 weeks. So for adoption, miscarriage, so when we talk about Maternity Benefit Act, we should also, it covers not only delivery of normal deliveries, it also talks about miscarriages. It also talks about your adoption, and all those leaves are mandated under the act. So this is how the act applies to the organization. Other than that, there's another thing which came out after the 2017 amendment of the act are the creche guidelines, setting up and running the creche in your individual organizations. When we talk about the creche, the number of it depends on the number of employees an organization has. It can be from 50. It varies from state to state. It is usually between 50, starting from 50 and going upwards. So if you have employees around more than 50, you should be having a creche, and the creche facilities should be laid down. This is the national guidelines, but the state guidelines have minute more details. So you should be following the state guidelines and in tandem with, and state guidelines are drafted in tandem with the national guidelines. So these are some guiding points for you. Similarly, you can take a look at your state guidelines. And then there is another portion of the Maternity Benefit Act, which are the regular filings. So the state-specific rules give out for the filings. I think we have our compliance calendar in it. Compliance calendar. It has a guidelines on maternity, some forms. It has given what forms to be filed. So you can follow that that one, and also you can follow, and most particularly the state rules on the type of forms to be filed for maternity benefit.
There's a question in the chat box on the Maternity Benefit Act. Is the payment of basic salary mandatory, or the gross salary including TADA and other allowances?
Everything, the average salary. So it includes everything. It's sorry.
Dishari, you're on mute.
Sorry, it is again getting stuck. I'm just resharing it. Sorry for this.
Yes, no problem. I think Dishari, while you come back on, another question that had come up in the pre-survey was, given that there are so many compliances and so many things that need to be paid out to employees, how can NGOs navigate funding limitations from their donors for covering HR and staff welfare needs like PF, insurance, gratuity, etc.? I'm not sure if the Pacta team has an answer for that, but if you do, that'd be helpful.
Yeah, I mean, again, not sure that we also have an answer to that at all. I think one way of ensuring is that, when your line items, when your budget line items are quoted, please ensure that, including the statutory payments, your budget includes the salaries based on actual payouts, right? Including the statutory payments. So that is one way of budgeting, and when you provide the budgets to your funders itself to do that. Of course, these days there are funders that are willing now to, ensure that statutory compliance is done, very, very methodically. So we do see that, in fact, on the other hand, we are seeing these days funders asking for, compliances on PF, ESI, etc. So, yeah, I mean, that is our response. Not sure we have, a different response.
Okay, so we come down to like we are almost at the end of the acts we are covering. We are coming to minimum wages, and again, it is not the act does not exclude the social sector, and therefore minimum wages actually lies to for skilled and unskilled laborers who are hired for a manual or clerical work. So the schedule 1 of the act has a list of work like which needs to be paid the minimum wage, and this minimum wage is again fixed by the states, and the cadence of this fixation differs. Like it can be some states follow a once a year method, some states follow twice a year method. You have to see if you are engaged in some skilled and unskilled labor falling in that category. You have to follow the notified wages for your state, and you have to follow the cadence. And usually we have seen for some states it comes in January, some states come in April. So January, July, April, October. This can be the cadence, or once a year they come out with the revision age wages. It's advisable for you to like assign one person to go through it. Whenever it is revised, you go through the revised rates and see how it can be implemented in your organization. And there are like the act follows, because it's an old dated act. There are specifics of it, like the wages set shall be paid in cash. When we say it is paid in cash, when we say paid in cash, it means bank transfers are also permitted, not in kind. Overtime payments are mandated. So there's are specifics of overtimes in that wage. Like when the notifications comes, the notification has the overtime rates also. So you have to account for the overtime rates, and you have to pay overtimes for that. And there should be a wage register. You should issue slips for them. So, and non-compliance, and this non-compliance has on the degree of non-compliance, or whether you are paying lesser wages, or you have not maintained that wage register for them, leads to imprisonment and penalty both. So that's on the applicability of it. I think there was a question on how it applies and which type of. So I gave which type of employment attracts minimum wages in the social sector. So you have to see what type. If you are employing a gardener or an electrician, or you have someone in a clerical position who is your office boy. You have to pay. So if it's an office boy, it's a clerical position, you have to pay the state's minimum wage, and they will be considered in the skilled category. And also there are three categories to be made for more specific: unskilled, semi-skilled, skilled. And you have to find out the categories in which they fall, and then calculate their wages accordingly. I'm not going into the Karnataka rules, but every state has their own rules, and you have to follow their own. So it's a central act having state rules, and you have to follow the state rules for deductions, payment of wages, overtime, working hours, everything. The basic of the, even when I am talking about overtime so much, the most of the acts rules follow that it should be 8 hours with 1 hour of break, with 6 days of working, right? And Sundays are usually off, or you say that 1 day off in between, like. So, so if you have to see what is the working hour. Some states for security guards, the working hours differ. So you have to check what is the working hour, what is the payment, and what is the notification of the payment, quantum of payment for them. Then we come to contract labor. So contract labor is something which is again, we have a lot of engagements through third party, like housekeeping staff, security guards, and these are the common examples of it, right? So in that circumstances, if you are engaging, then you have to take a registration, contract labor registration. Then if you are as a principal employer, who is a principal employer? This is very important concept. If you are engaging a third party, and you are responsible for the supervision of the contract, supervision and control of the third party, in the supervision and control in your establishment. Although they are employed through third party, you are a principal employer, and there are obligations for you under the act in that sense. And if the contractor fails to pay the wages or statutory dues, it ultimately falls on the principal employer. So as a principal employer, you have to be very cautious while engaging with the third party contractor. You have the agreements which you enter into with these contractors should be very thorough on the responsibilities, and you should be asking them for accountability, whether they have been paying, you are paying the wages to them every month, for the wages to go out to the contract labor, but you have to ensure that they are paying it. Because ultimately what happens is, if they don't pay, it will come to you. So the law will not listen that we have paid out to the contractor, we don't know what happened after that. You have to ensure after you pay them, the contractor, it is paid out to the intended beneficiary, the employee, the laborers or the workmen in this case, right? And again, the cost of non-compliance is imprisonment and penalty. So you have to be very cautious while you are engaging with these third-party contractor, and your agreements should be thorough. Equal remuneration is, again, you cannot be discriminating within your organization. You have to pay equal remuneration irrespective of their sex, caste, and everything. So that's a simple act. I will not go into the details of it. Before that, would you like to answer the questions?
Yeah, I'll just bring a couple of questions, and audience, please feel free to add any questions that you currently have to the chat box. I'm picking up a couple from the pre-survey. So there was a question around what should NGOs consider when implementing leave policies, managing work hours, and setting public holidays to align with local labor laws. You've covered some of it as you talked about the acts, but if there was a summation of that, how do they go about setting work hours and leaves?
Firstly, you have to follow your Shops and Establishment Act. You have to go to your state-specific. Suppose you are in Maharashtra, check out Maharashtra Shops and Establishment Act. There, they have specified the working hours, and also the overtime till which they can do, and also the number of leaves they are entitled to. They will have a threshold. Some has like 12 sick leaves and 18 earned leaves. So you have to give that threshold to them. Over and above, you can provide anything, but the threshold should be according to the act. And the public holidays, there are no specific laws. You have to give 4. After that, over and above, whatever your organization, that there are standards like 10, 12. Each organization differs from organization to organization, but 4 you have to mandatorily give. Other depends on your discretion.
Okay. Another question that's come up is how do organizations approach training bonds for employees, especially if the training requires the employee to travel abroad?
Training bonds, like you want to have. I didn't get the question.
So basically, an employee is undertaking training, but you want to ensure that the employee continues in the organization even after the training. So you execute some sort of a bond or a contract.
Yeah, there have been judgments holding
Yes.
that these bonds are not, legal. They are illegal.
Yes.
We are not allowed to do it. But notwithstanding the fact, organizations continue to execute these types of bonds. The enforceability of it will be questionable. It may create some sort of a hesitation for an employee who has taken a training abroad to leave. So it will give you that value, but enforceability is questionable. Courts will not uphold the enforceability of such a bond.
I think you can proceed, Dishari, and if there are any more questions, we can take it up at the end.
Okay. So I think what is happening. The last part of this discussion, we are at almost the end of the discussion. So while we have given a glimpse of what the type of engagement is, what are the laws which applies to them, now it is very important to understand then how to document it, right? Documentation is the main ultimately the crux of it, how you document it and how you execute that document, and how with what clarity you can execute that document. So when you are having a employment agreement, you should have certain clauses which makes it equitable for both the employee and the employer, and makes the conditions of employment are very clear. So the basic thing, very crucial, is the job title. And why the job title and the description? Because at the end of it, when at the beginning we were discussing consultants and the employee discussion, who is an employee and who is a consultant, that job title, the description, the type of work that person is doing becomes the crux to distinguish between these two type of engagements. And therefore, in clearer terms, you establish that what is the job role, how you are being engaged, in what capacity you are being engaged. And that also has a repercussion on the employee's rights, right? If you are an employee, then you have certain rights. So that will flow from how the first of the scope and the job title is structured. So, for example, I can give you an example that someone is say like she is a senior consultant. Okay, she's engaged. You are being engaged as a senior consultant. Your job description is XYZ, and there is no term specified, but the job role seems like it's a regular job. You are as a managerial. The job is a managerial job, but you are terming it as a consultant. Does that make you a consultant? The answer to this is no. It is not a consultant position. It is a managerial position. Whereas you are engaging a CA for he will give you a consultancy on your accounts, on your filings. So you clearly say that you are being engaged as a consultant for this. There is no specific like this assigning of a job title to that. So this is a basic distinction I wanted to bring in. Then what are your salaries and your perks? When we are saying the salary, so sometimes we said that you have this mistake is done in a lot of places, saying that it's a consolidated salary of this. If you are a fixed term employee and you get a consolidated salary of 30,000 rupees, but no PF consideration was made, nothing was said that, and you do not give that benefit to that person, even though it is a FTE, it's a fixed term contract. Or you say that you do not clearly lay out, clearly break up the contributions. Even for PF, contributions are not laid out properly. So what are the perks? What are the salary? Please have it clear. So and also to understand, go back to the basics of contract. A consideration should be there, right? And this salary is a very important part of that. Then coming to the first, which is linked to the first point, type of employment. I'm not going into that. Then comes to the terms and conditions. What are your terms of your engagement? How many leaves you have? What is the working hours? What are the how to use the resources? What are the policies you have? You can tie it up to your HR policies. What are the allowances given to you? What is the code of conduct? Everything should be and everything should be laid out there, or you link your policies. You tie up your policies with this working condition. You direct the employee towards your policies, and it should be practiced that the employees should be made aware of the policies which applies to them. It's a very important practice you need to follow. In a ways to retain employees, or there was a question how to retain employee. We are not the HR experts, but we can at least say that to have to retain employees in like financial constraint situations, to have proper policies. Be flexible with them if needed, but having proper policies are important, and making your employees knowing making your employees aware of it is also important, and specifying it in the your terms and conditions of your engagement letter. Then your termination and exit process. So if it is a fixed term contract, if it will have a term, that the term might be for 2 years, and then the contract expires and the exit process is laid out. But it is a full-time employee, then the termination should be specified. It can have, usually the recommended way is It can have both. One is both party can terminate without cause, the convenience, and another can be for cause, right? In when there is a cause for termination, maybe there is a misconduct, non-performance, etc., etc. You follow a proper process. Due process means following that you will give a show cause notice to that person. You take the response of the show cause notice. If required, have an inquiry. If not required, you can terminate then and there. But having a proper process and also laying down the termination clause properly, that both the parties have the right, both the parties have opportunity to terminate the contract for without any cause. But if the employers have a right to terminate the contract under specific conditions, lay out the conditions. When you encounter such conditions, have a proper process to terminate that employee. So that's how you lay out the contract itself. And then another important clause is having a confidentiality clause and a data protection clause, because nowadays you deal with a lot of like personal data and also processes, like processes which are confidential to the organization, right? Having a proper confidentiality clause and a data protection clause and the responsibilities of the employee to protect it, and how to mitigate risks of it being misutilized or leaked should also be taken care in these clauses. So having these clauses are also important for you. So yeah, so here I conclude, open for any questions.
Thank you, Dashari. There's one question in the chat box we can take up, and maybe one other, depending on whether people have any more questions. So the question is, I think Nivedita is answering it in the chat box as well. How does a retainer engagement work? Will an individual engaged in retainer contract be termed as a regular employee? Nivedita, maybe you can just answer that aloud as well. Yeah.
Yeah, so see, if it is a retainer with a chartered accountant, like the Shari was describing earlier, right? And it is, that is a specialized services where the person whose retainership services we are taking is a specialist, and it does not take the color of employment. And we did speak about what is the color of employment in terms of, whether they are taking substantial directions, is subject to management, supervision, subject to leaves and other, day-to-day requirements of the employee, subject to the, appraisal process. As long as the retainer is not subject to all these things, then they will not be a regular employee. But and they take a specialist role, where they are bringing a specialization or an expertise to the table, and they don't directly take instructions from the employer, then it will not be considered. So I think what we are trying to also drive home is the fact that, just by using various terminologies, it does not mean that if we call somebody an employee, a retainer, or a contractor, they become a retainer or a contractor. The court will always delve into the real structure, or when we go into legal enforcements, the statutory authorities will always delve into what is the real structure, not just by the language that you have used in the agreement. So when you draft these agreements, please ensure to draft it appropriately. Yeah, this is also just a plug for Pacta's upcoming sort of training program on filings under the FCRA, and some recent changes under the Income Tax Act, due to which some of the filings are changing. We are doing this on November 22nd and November 23rd and 24th. Please do sign up for this for those who are interested. The link will allow you to sort of register for this training program. But We remain available for any other questions now, or if you want to reach out to us one-on-one, then feel free to write to us, follow our work at pacta.in. We also run Pulse by Pacta, which is our monthly newsletter. If you go to our website, then you will be able to just scroll to the bottom of the website and subscribe to Pulse by Pacta. We run a newsletter carrying legal updates for the social sector, where we sort of simplify any new legal concepts for social sector leaders. So feel free to engage with us in any way that you deem fit. Thanks so much for giving us the opportunity to present and for the very enthusiastic engagement with the content that we shared.
Thank you, Nivedita. Thank you, Dashari. And would request you to stay on for the next 10 minutes or so. And if there are any questions that any of you still have, you can put it in the chat box and Dashari and Nivedita can take it up over there. But in the meantime, would like to call upon my colleague Kavita to just take the next few minutes to talk about a very exciting new tool that we've created at Atma. And yeah, over to you, Kavita.
Okay. Thank you so much, Aishwarya. And good evening, everyone. And thank you so much, Nivedita and Dishari, for the very informative session today. So really appreciated all the way in which you all answered the questions. I just want to introduce myself quickly. I'm Kavita. I'm working with Atma as a lead consultant programs. And I would like to take you all through one of the resources that we have built for the social sector, especially for the nonprofit organizations. So this resource is called as the intermediary database. Some of you might have heard of it, and we will be sharing the link with you all soon in the chat box. We just wanted to take you through the demo so that we can show how you can use the database and how you can navigate through some of the functionalities and then use it to identify certain organizations that can help you in your capacity building journey. So just to give a brief context, the whole initiative on having this database actually is in partnership with Gridspan under the Pay What It Takes India initiative. And for those who are not aware, this initiative is trying to build knowledge and advocacy around the true cost for a not-profit organization to showcase the social impact of their program. You can read more about it on the website as well, on the Gridspan website, about what this initiative is. But the idea was to develop different tools and resources and make it freely accessible to the sector so that they can start utilizing some of these for their own development and growth. So one of those was creating this intermediary database, which has a curated list of 100+ organizations and independent professionals. And they provide services or programs under different organizational areas like strategy, fundraising, monitoring and evaluation. We'll go through the entire list as well on the Excel sheet. But this is the kind of database that helps you to identify organizations who provide support within those specific organizational areas. And you can also reach out to them and you can connect with them as well. Right. I'm just going to share my screen so that I can take you all through the database. This was also launched in November 2023. So it has been a year now. It's going to be a year since the launch. And we are very excited because we kickstarted with sharing this in our network, sharing it across different nonprofit organizations that we partner with, different intermediaries. We have already got a very overwhelming and positive response in terms of the views and the accessibility that people have shown. And today we hope that, by taking you through this session, you'll be also able to use this further. Okay, I'm just going to take you all through this. Yeah, I hope you all are able to see my screen. Right. So currently this resource is housed in a Google Sheet. This is how we started because it was a pilot initiative for us as well. And this sheet is it's open, so it's accessible to all. Some of the cells you will see or some of the sheets are locked in this, so you might not be able to edit it, but you will be able to access all the functionality and features of the database. Okay, coming to the first tab of the sheet on the database file, it just gives you an introduction of what the intermediary database is about, the partners who are behind this initiative, and also gives you guidelines on how to use some of the other tabs. So we have two other tabs in the file. One is searchable and the third one is intermediary details. The searchable tab will help you to select the areas in which you need support and go through the list of organizations within those areas and help you filter through some of those areas. And then the intermediate details is the detailed list of all the 100+ intermediaries, where you will get more detailed information about what work they do, what impact or services they have been offering, and how you can reach out to them and things like that. So let's go through each of these tabs one by one. Moving to the searchable tab, there are 3 filters that we have provided over here. The first filter talks about the functional expertise area. So here you can select the area from the drop down. We have listed around 13 capability areas. This is also coming from some of the analysis and research that we had done on organizational development with Pritspan. And based on that, we have been able to identify these 13 capability areas. So just to give you examples, there's strategy, there's governance, there's leadership, there is monitoring, learning and evaluation, communications, human resource, fundraising. So some of these areas are the specific needs that you might have. Based on that, you can search, right? So here, if we are looking at, for example, human resources, it will show you results of the list of all the organizations that are providing services or programs in the area of human resources. You can also see the result found over here as 14. So 14 such organizations are providing these services as expert services. The second part, I would just request if, while I'm doing the demo, please don't use the functionality so that otherwise it changes for everyone, right? The second part over here is the select the area of support. So within human resources, again, there are different subcategories that you can select. So for example, say in HR, there's something to do with hiring. Then there is HR policy. Somebody is working exclusively on HR policies or on HR processes, volunteer management. So these are the different subcategories within each of the functional areas. And you can select if you have a very specific need that for HR, you need support, say on HR policies itself. So then you can select HR policies. So you will get a list of all the organizations who are more expertise in providing you support in that policy area. Or you can also select just all. And then there is a third filter, which talks about the type of service or program. So again, when you look at the drop-down list over here, you will see different options, like there is a consulting service. So there are organizations who offer consulting, right? They offer services in terms of being consultants to your organization. Then there are organizational capacity building programs like accelerators, incubators, who will actually design a program and you'll be inducted into that program. Then there are courses, training sessions, academies, all of those things are also available online. There is technology solutions that are available. And then there is research advocacy, somebody who's providing you for pure research advocacy services. So these are the different categories of support. You can choose to select one of these categories and say, okay, like in a capacity building program, how many organizations are like supporting us, or you can just select all and you can still. So these 3 filters can be used independently or interconnected to each other. Based on that, you will see the list appears over here. We are capturing some very basic details on this sheet where we are talking about who is that service provider, the name, or the type of organization, whether it's for profit, not for profit, what location are they servicing. So this is not the location where they are based, but the location where they provide their services. So is it all across India, pan-India, or is it in a very specific state in India? Types of services programs comes from this filter, whether of those options, which are the ones that they have selected. So it's possible that one organization can be providing services across multiple areas, right? So they could be providing capacity building and courses as well. So they would have selected more than one option. Then their names will appear in both the options when you select it. A brief description about the organization that's providing support, so you can read up about them over here. And we have also provided like 3 areas in which they have chosen functional expertise. So 1, 2, 3, here you'll be able to see which are the top 3 areas in which they provide support to nonprofit organizations. And then we had also asked for certain references. So they have provided references on names of organizations that they have worked previously with. So you can just get an idea about the kind of organizations they've worked with. And you can also look that up online on their website. So this is very basic information. If you want to read more about them, then there is a way to do that. There is a link over here, which will take you to the next tab for that particular organization. So when you go to the tab 3, which is intermediary details, you will be able to see the list of all the 100 organizations, right? So from 1 to We have 109 so far. So you will be able to see the list of all these organizations. There are more details over here apart from the fields that we covered in the previous tab. So there would be the point of contact person. The email ID is also provided here, so you can directly write an email to them. About the service provider, again, some of those fields we have covered. We've spoken about who are the team members, who's the CEO, what's their profile. The sector of work, they also have selected which areas they work in, the communities they serve. They have also mentioned some of the impact of the services and program they offer. How do they see that? There's a link to the website or the LinkedIn page that you can just click and explore further. There are also things like there's a huge description of also the kind of services that they're actually offering. So you can exactly know what support are they offering to nonprofits and see if your needs or requirements fit within that or not. So you can read through this also. Also, we have checked if there are grants that are being offered by some of these organizations. And in terms of the cost of services, are they offering free of cost services or is it a paid service? The language of communication that they use and the areas in which they support. Now, initially, if you would have seen in the second tab, there was a list of 13 areas that we had put down, right? So we have responses from these organizations who have marked out of those 13 areas, which are the areas that they are providing support in. So you will see the list of all these 13 areas. Wherever they are providing support, we have tick marked as a yes. So you'll be able to immediately visually see that, out of all these areas, where that organization is providing service, and of those, which are the top 3 functional expertise areas, so that you know that this is something you can prioritize and reach out to them first if you have a need in that particular area. You can also read more about each of these areas. If you just click on the yes, it will take you to another column where you can just read that within strategy, what do they offer? If it is leadership development, what do they offer within leadership development? And you can scroll and read through some of this and or just go back to the list of the 13 capabilities, right? Okay. So this was just like a glimpse of what kind of information we have put down over here in the database. But of course, you can read more about it on their website, or you can reach out to them directly and talk to them about your needs, and also, explore some of these fields as well. One thing I wanted to also call out is that all of this information has been provided by the intermediaries themselves, by all these organizations who are listed here. They have actually filled in the survey form and they have provided the information to us. So it's verified from the source, from them itself, and we have not taken this from online sources at all. So this was an exhaustive exercise where we did reach out to all 100. In fact, we reached out to more than 100 intermediaries, and wherever they were offering services which we felt would be useful for the NGOs and would also fall under the 13 areas that we have listed down. We have included them in the database from our networks. So do go through this list and do get back to us and let us know. There's also a tab on the first page which says feedback form. If you can just fill out the feedback form once you have gone through the database, this will really be helpful for us because it will give us insights into what are you really looking at and what kind of connections do you want to make through the database. So do fill in the feedback form. We will be sharing this with you as well post the webinar on email. So you can go through it and let us know, reach out to us if you have any further questions on how to use the database, or even if you want to connect to somebody from the database, you can reach out to us and we can help you navigate through that. All right, I'll just stop sharing my screen. I think the link has already been provided in the chat box. Any other quick questions or thoughts anybody would like to share before we close the session? All right, thank you for your quick comments on the chat as well. And I do hope that each one of you will go back, explore, look at the database. Again, just to summarize, it's a useful tool and resource which will help you to identify some of these organizations providing support to you and actually help you to connect with them. And do reach out to us if you have had any such connections or experiences with the intermediaries. And just the last announcement is, yeah, we are looking at more names to add to the database. So if you do know of somebody who's not part of the database, please do feel free to recommend them to us. So
Thank you so much. Thank you so much, Kavita. And thank you everyone for staying on and being part of this session. We will be sending the recording and the deck to all of you, and any additional resources that Pacta would like to share. We'll be sending that to you post the session. Thank you so much. And please join us for the next Atma webinar.
Thank you. Thank you.
Thank you.